Robert Klonoff has served as the Dean of Lewis and Clark Law School since 2007. He is the author or co-author of several books and numerous articles on class actions, appellate litigation, and trial advocacy. He has also served as an expert witness in many class actions, including the recent British Petroleum oil spill class settlement.
Thank you. I'm going to have my hands full with this device, so I'm not going to use that microphone that you were using. I'm going to talk about the British Petroleum oil spill litigation, and as Alex said, I played a major part in that case, so I'm going to give you a behind-the-scenes look at the litigation and talk about how it was resolved, and bring you up to the date on the latest developments, which are occurring even as we speak, a quite unusual twist in the case that's now developing. This was the largest oil spill in world history. And the resolution of this case could only occur in a country that has a class action device, such as we have in the United States, and has a contingent fee arrangement whereby lawyers can be paid out of a settlement pot. And believe it or not, in most countries, contingent fee arrangements are considered unethical and illegal. And then when you couple that with the fact that most countries don't have class action mechanisms, you really don't have a scenario that could have led to what I believe is a superb settlement of this unfortunate disaster. So the end result of this case and the settlement in the case is worth over $7.8 billion. It represents the largest civil settlement in U.S. history. The upshot is that the lawyers in the case are going to end up getting hundreds of millions of dollars. And before you get all aghast over that, I want to put it all into context, because my view is that that's a good thing, that you need to incentivize lawyers in order for these kinds of cases to be brought. And this goes back to the point I made in my question yesterday to MC Mehta, that without an incentive system, these cases won't be brought. And so you'd have a situation where no one would be compensated, which I think is a very bad thing. So just to give you a little bit of background on this spill, which took place in April of 2010, there were 11 deaths that took place at the time of the explosion. And the discharge of oil continued for about 3 months. Oil washed ashore in Louisiana, Mississippi, Alabama, Florida, and Texas, causing all sorts of damage, economic harm to businesses, hotels, restaurants, environmental damages, massive personal injuries for cleanup workers and other people who were exposed to the oil. Altogether, more than 4 million barrels of oil spilled into the Gulf. And the range of estimates are between 4 and 5 million. Most experts put it in the level of 4.9 million barrels. This is a lot of oil. It was an absolute disaster. And as I said, you had economic loss, you had all kinds of other damages that I'm going to talk about in the context of how this case got resolved. So let me give you a little bit of background. This case raised all sorts of complex interrelated litigations. You have civil enforcement by the government, you have criminal enforcement, and you have private lawsuits. And BP and the other defendants, who I'll talk about in a moment, were subject to all of these multi-layered regulatory schemes. One of the main statutes was the Oil Pollution Act of 1990, which was passed in response to the Exxon Valdez spill, which up until that time had been one of the largest spills. And that case went on for decades. It was a poster child of how not to resolve one of these cases because it went on for so long, and the personal injury aspects were ultimately never resolved. So there was never compensation for the vast majority of personal injury claimants. So you have a whole variety of laws that come into play here, and in the interest of time, I'm not going to go through them all, but you have federal statutory law, you have state common law, you have maritime law because the rig was considered a vessel, so that brings into play admiralty law. So a complex maze of case law and statutory law at issue in the case. I'm going to skip over these in the interest of time. So BP is the most famous of the defendants, and everybody talks about the BP oil spill because BP operated the Deepwater Horizon, but there were several other defendants. I'm going to talk about the role of some of these other defendants in the case. And the settlement that I'm going to address was only BP's portion. So there are potentially all sorts of events that could occur down the road as I think eventually these various other defendants are going to reach some kind of resolution as well. So as you can imagine, I mean, this just brought out every lawyer in this part of the country filing lawsuits. You had personal injury lawsuits, wrongful death cases, economic damage, property damage, breach of contract, securities fraud cases. You don't ordinarily think about that, but the failure to disclose to purchasers of BP stock the fact that there was this risk. ERISA cases because people's pensions dropped in value, shareholder derivative actions, lawsuits by state governments, foreign governments, the federal government, cross claims, counter claims. I mean, this is, depending on your perspective, either a civil procedure dream or nightmare. Just incredibly complicated. For people like me who love complex litigation, it truly was a dream, a really, really fascinating set of issues. So British Petroleum getting terrible, terrible press as a result of this. I mean, just vilified internationally. The spill and the oil-laden wildlife that were filmed and shown around the world, birds who couldn't flap their wings because they were covered with oil. The company was threatened with, just massive public fiasco in terms of their reputation and their ability to continue in business, and they decided they were going to be proactive. So they very quickly after the spill established a $20 billion trust fund, and they said, we're going to put this money aside to resolve all of the litigation coming out of these various harms. And early on, they set up a claims process, and you'll remember President Obama was part of this, and Ken Feinberg, for those who know who he is, a very famous mediator. He was the man that resolved the September 11th compensation claims. He was the car czar. He's been involved in the savings and loan situation. Anytime there's a crisis, you find Ken Feinberg. And so he established this claim facility and did quite a good job and paid out in a very short period of time $6.2 billion in individual settlements. I say it's short because you're talking from August 2010 to March 2012 to compensate more than 1 million claims by over 200,000 claimants. And there was no infrastructure, there was no formula, there was nothing. Ken Feinberg had to make it all up in order to resolve it. And people initially thought this was great because he was being compensated at a high fee, but he was being compensated by the hour by British Petroleum. And people were saying, all right, this is great, we're keeping the plaintiff lawyers out of the picture, and all the money's going to go to the victims. This is terrific. Well, the criticism started mounting and it became massive. People were saying, they talked to their neighbor, well, how much did you get? Well, I got 100,000. Well, I only got 50,000 and my claim's stronger than yours. And there were no published guidelines. You'd go in, you'd present your claim, you'd get a check. So there was, you really had no basis to figure out if you were being paid fairly. And that's a formula for people to complain. And I'm not in any way suggesting that Ken Feinberg was unfair. He's a man of great integrity. But nonetheless, he was faced with a situation where people weren't happy. A lot of people were being denied their claims because they didn't provide proper proof. For the most part, he wasn't paying out any money for personal injury claims, and people were upset about that. And then there became a lot of publicity about the fact that he was touting himself to be independent. And people got upset about that. They said, how could he be independent? He's being paid by BP. So clearly, he's not independent. He's not a public servant. He's hired by BP, and he wants to conserve BP's resources. And again, I'm not casting aspersions on Ken Feinberg. I truly believe he was trying to compensate people fairly, but he had to deal with this massive negative publicity. So all these hundreds and hundreds of lawyers are saying, okay, it's our time. This isn't working. The Gulf Coast claims process is a failure. Let's do it by litigation. Well, how do you resolve hundreds and hundreds of lawsuits? Well, we have in our country the multi-district litigation statute, 28 U.S.C. 1407, and it basically sets up a special court of 7 judges who have the authority to consolidate and transfer all lawsuits in federal court. Most of these claims were in federal court. Transfer them all to a judge, a single judge. Well, which judge? Well, any judge that this panel decides they want to transfer the case. And I could spend hours talking about the multi-district litigation panel and how do you get cases transferred to the judge that you want. You know, the plaintiffs want to get a pro-plaintiff judge. The defendant wants a pro-defense judge. The Louisiana lawyers want to get a Louisiana judge so they can be the lead lawyer and they can capitalize on the attorney's fees. The Texas lawyers want a judge in Texas. So all this is going on. And you've got hundreds of lawyers competing for this coveted position of, number one, having the judge you want handle the case, and then number two, being appointed by that judge as the lead lawyer to handle these cases. So the purpose of the MDL process is to avoid duplication, to provide efficiency of resolution, to conserve resources. In theory, all of the cases are supposed to go back to their original courts for trial, but the reality is virtually all of the cases settle, and they settle under the supervision of the multi-district litigation judge. So in August of 2010, the multi-district litigation panel centralizes all of these actions in the federal district court in the Eastern District of Louisiana. And that makes a lot of sense. I mean, the spill covered a wide area, but the core area that was harmed was the area around New Orleans, Louisiana. And the cases were assigned to Judge Carl Barbier, who had some of the cases, a very, very fine judge. It was, in my opinion, a terrific decision to assign the cases to Judge Barbier. And immediately, both the defendant and the plaintiff lawyer said, whatever else you might say about this process, we're happy that we have a judge with great integrity who doesn't have an axe to grind here and doesn't have any kind of an agenda. And he said early on, I am not going to be supervising these cases for 20 years. So if you have in mind that this is going to be another Exxon Valdez, you've got another thing coming. And so he decided that he was going to move these cases quickly. He was going to set trial dates very promptly. He was going to force the parties to the table. I won't go through all of the analysis of the MDL court, but suffice it to say it made sense that there were common issues that made it appropriate to consolidate all these cases, the major issue of which is what caused the explosion and what role did the various defendants play in that. So following the centralization, the parties began a whirlwind discovery program. Judge Barbier appointed a group of lead counsel, most of whom were from Louisiana. There were some national counsel from California. He picked some of the very best plaintiff lawyers in the United States. to be on the committee that led this litigation. These are prominent lawyers from tobacco, from many other mass torts. They had incredible experience dealing with complicated cases like this. So in a short amount of time, they took over 300 depositions. Both sides produced over 90 million pages of documents. They hired countless experts, exchanged more than 80 expert reports, had weekly discovery conferences. They were just moving it at great speed to try to get information about where these cases should go. March 2012, and this is unheard of, we're talking 2 years, the parties announced a complete resolution of all of the civil claims. And I should say parenthetically that all of the claims were consolidated to Judge Barbier except the actual death claims. Those were put aside, and the securities fraud and ERISA cases were separately consolidated before a federal judge in Texas. This settlement is presented to Judge Barbier. Under the federal rules, he has to first preliminarily approve the settlement, then send out notice. This was a class-wide settlement, so you have to authorize sending out notice of a class action settlement, giving the potential class members an opportunity to come in and either object to the settlement or say they didn't want to participate and thereby opt out. So let me give you just a quick primer on class certification, because in order to settle a case as a class action, you have to qualify as a class action. So you have to have a definition that's clear and that basically allows for notice and an opportunity for class members to identify who they are. You have to have representatives who will vigorously represent the class, who are members of the class. Their cases have to be live. You have to meet the requirements of Federal Rule 23, the Rules of Civil Procedure, so it has to be sufficiently numerous. Obviously, that's met here. You had hundreds of thousands of claimants. I've already mentioned the common issues. The claims were typical of the representatives. They were all suffered harm as a result of the spill. I mentioned the adequacy, so the representatives who were picked had to be such that they would vigorously represent the claims. This was a class under B3. There are various kinds of class actions. I won't go into the details, but a B3 class means you have to have common issues predominating over individual issues, and the class action device has to be superior. So then you have a whole infrastructure for settling. As I talked about, you have to first have the preliminary approval. Then you have, after the notice, a fairness hearing. Because it's a class action, parties can't just settle cases on their own. They have to appear before the judge and justify the fairness. And there are a whole variety of factors that a court considers in deciding whether a case is fair. Can't be fraud or collusion. You have to look at the likely duration of the case if it didn't settle, the stage of the proceedings, how much discovery was done, the range of possible recovery, the opinions of counsel, and ultimately how much was obtained versus how much could have been obtained as a result of litigation. You have to look at ultimately the fees that are requested and whether those are reasonable. And then there's a process for the objectors to the settlement to come in and object. The court hears all of this. People can opt out if they don't like the settlement. And then in the end, the court has to rule on whether or not to approve the settlement. So how did I get into the case? Well, I got into the case because obviously both sides, having decided they wanted to settle, wanted to put forward their best foot. So number one, they wanted to convince the court that yes, this was a class action. So they wanted to bring into the case class action experts so that they weren't talking as advocates, but that they had somebody with objectivity to come in and say, yes, this was a legitimate class action. Second, they wanted people, again, with objectivity and come in to say, this settlement is fair. And then finally, and this hasn't happened yet, but they will want experts to come in and talk about what reasonable attorney's fees should be. So there were 4 experts altogether that were brought into the case, and I'll talk about them. I was the only expert who addressed all of these issues. So I was really the most comprehensive expert in the case. So there were actually 2 separate but interrelated settlements. There was an economic settlement, and then there was a settlement of all the medical claims. And the economic settlements, just very simply, depended on where you were located. So there were geographic bounds. People who were closer to where the spill occurred were eligible to receive more money. And there were a variety of economic claims that were compensated. So you had claims for business loss, claims for real property damage. There were vessels that BP hired to go out and help with the cleanup, and those people were compensated. There was oil spill damage to some of the vessels. There was compensation for that. There were people who were identified as subsistence fishermen, people who lived off the river. They were compensated. And then there was a special compensation program for shrimpers and oyster sellers and so forth. Let me just move now past the economic in the interest of time here. There was also a separate medical settlement, and these were people who worked as cleanup workers in the settlement, and people who resided in certain areas close to the spill, so they were likely to have either gotten rashes or breathing issues or things that would result of being close to the spill. And so there was compensations for particular kinds of injuries. The settlement also provided, essentially, it's not called a medical monitoring program, but a periodic medical checkup program where people could come in and get checkups to see if they were suffering from much more serious illnesses, which wouldn't have manifested themselves at the time of the settlement. The settlement was really for more minor physical injuries, but it offered a back-end litigation option which allowed people who down the road would develop cancer or other serious injuries to come in and pursue those claims. It was really extraordinary in that sense. They weren't waiving those settlements. They didn't release. Most settlements, you release every claim from the beginning of time, known or unknown, but these people preserved their option to bring claims for serious injuries. So the overriding theme of this settlement, and the reason that I was able to come in and provide such enthusiastic support for the settlement, is that BP's goal was full compensation for business loss, full compensation for real estate harm, and full compensation for physical injuries. It's absolutely unheard of to have a case like this. In most class actions, you're lucky if you recover pennies on the dollar. So it was an extraordinary settlement. In fact, what made it really unusual was that many of the objections to the settlement were not by people who were claiming they were getting too little, but by people who were defined to not be part of the settlement, and they were objecting because they didn't get the chance to participate. So from my standpoint, as an expert advising the court, I could say, obviously, this must be a fair settlement because everybody wants to be part of it. And there's really no stronger indication of how good a settlement is than the fact that people are knocking on the door saying it's unfair that they were excluded. So just quickly, you can see the whole variety of physical injuries that were compensated as a result of this settlement. And so let's talk about the objections quickly. As I said, non-members wanted to be included. Some people came in and said that the Gulf Coast claims facility was superior. Well, that didn't resonate because, as I said, there's been so much criticism of the Gulf Coast claims process. Why are people objecting? Well, some of the people are professional objectors. They're lawyers who are coming in. They were unhappy that they weren't selected to be the lead lawyers, that they weren't going to get the fees. So they were looking for a way to derail the settlement. One way to derail it is to come in and object and go back to square one, which is the Gulf Coast claims process, and then to come back in and say, well, the Gulf Coast claims process isn't working, so now come in and take my settlement, not the one that I objected to before. Claimants were arguing they didn't know the exact compensation that they would get, but in fact, this settlement occupied phone book thickness documents explaining in great detail how you calculate the settlement. I had never seen such guidance in any settlement. So people who wanted to know what they were going to get, they could figure out quite precisely how much they would get as a result of the settlement and whether or not, in their view, it was a good settlement. People complained about the definitions of the various zones. The closer you were to the spill, the more you got, and they said, well, why does this guy get double what I'm getting when I'm only a block from where this person lives? So everybody was just trying to get into the situation where they could get more money, and as I pointed out to the court, no matter where you draw the line, people are going to object, so that's not a legitimate objection as long as the line you draw is reasonable. Lots of complaint about the fact that this didn't qualify as a class action. Some of these were quite interesting because the general law on class actions is that personal injury cases usually aren't appropriate for class certification. But here you had one overriding issue. You had maritime law governing these cases, and so you didn't have a situation where you had multiple state laws applying. And the really difficult causation issues were the issues that would occur at the back end if somebody developed cancer and there were multiple causes. If somebody on day one is fine and on day two, after going out and being exposed to oil, suddenly comes out with a skin rash, it's a pretty good argument for causation. So you really didn't have the serious kinds of concerns that you have in most of these mass settlements. So what does a class action expert do? Well, first I reviewed all of the objections, and I offered my own opinions. I actually filed 4 separate lengthy documents opining on class action issues, on the fairness issues. I went through objection by objection, responding to the points that were made by the objectors to try to advise the court on whether these objections had merit. As you can see, there were 4 experts, Professor Coffey from Columbia, Professors Zakharoff and Miller from NYU, and myself. And as I said, my role is a much, much broader role than any of the other experts. And the court relied very heavily on the expert testimony. I was cited over 50 times in the course of the opinion. But who's counting, of course? My research assistant actually did a search and told me, and I was quite pleased to see that. Some lengthy quotes as well, which I really liked. And the court noted that because all of the experts had been critical in their scholarship of various class actions, we weren't sort of knee-jerk class action proponents, but had been critical in a lot of cases, that gave our testimony added weight. So I'm going to go over, skip over all of the details here, and fast forward now to today. This case has taken a very, very interesting twist. Because as I said, what made this case so superb as a settlement was that there were no ceilings on it. Although it was estimated to be $7.8 billion, the scheme of the settlement was that everyone would get full compensation. There were some exceptions, but those were minor, and I'll put those aside. But for the most part, everyone would get full compensation. And the settlement wasn't capped. BP said, we will pay no matter how much these claims are. Anybody who submits a claim and it's calculated pursuant to the formulas that were adopted in the settlement, we will write a check and pay. So what do you think the objection now that BP has? BP is now objecting to the settlement after having come in and urged the court to adopt the settlement. What do you think the objection is? I'm going to ask you a question rather than you all asking all the questions. Say, too expensive. They are coming in, and in fact, the headline of an article that just came out days ago, BP to seek Prime Minister Cameron's help as oil spill costs escalate. So BP wants their Prime Minister to go and tell President Obama that this settlement is too expensive. How President Obama can now come in and unravel a private settlement is something that I don't fully understand. And it's quite interesting because the commentary, and the industry observers have had a field day with this. They've said, BP, you're right. This is a really, really expensive settlement. That's what everybody was saying and what you were saying when the court approved it. That's what made this such a great settlement. But it's expensive for reasons that you knew at the time you entered into the settlement. And all of the things that you're complaining about here are things that were apparent at the time of the settlement. So one oil industry analyst said, the problem is that BP's written a blank check to the businesses of Louisiana and told them they didn't have to prove causation. You can argue that the settlement is being abused, but that was the settlement that BP reached, and now they're trying to wiggle out of it. So it's not good for BP, and that one of the questions I wonder, and I wish I were a fly on the wall, is what are the conversations between BP and BP's lawyers? What did the lawyers tell BP? So is this a problem that the lawyers didn't fully explain the settlement? Is this something that could lead to a malpractice suit? Or is this a situation where the lawyers were absolutely clear and BP either didn't hear or didn't want to hear? So it's very interesting. The case is on appeal now to the Fifth Circuit. A settlement is a final judgment. So the case goes up to the Fifth Circuit. But Judge Barbier is now faced with all these efforts by BP to now unravel the settlement. And billions of dollars have already been paid out. I think the latest I read is close to $3 billion has already been paid out. So BP's got to move quickly here and get some relief, or they're going to go over the $7.8 billion before they even get a resolution of any of the arguments that they're trying to make. So this is a grossly oversimplified version, but if you want to know all the nitty-gritty, you can do a Google search of Judge Barbier and BP oil spill, and you will pull up two decisions over 100 pages each that detail the settlements in great detail and talk about all of the issues. And then you can follow up with some of the recent decisions by Judge Barbier ruling on various motions by BP to try to unravel this thing. Judge Barbier has shown great patience, but I must imagine that he's not pleased that this flurry of motions is coming from one of the parties who was so enthusiastic about this settlement. And I wonder in the end what this is going to do for the reputation that BP was trying so hard to preserve as a result of all of this. And I was up there as an expert. I certainly wasn't applauding BP for the conduct that led to the litigation, but I was applauding BP as a corporate citizen stepping up to offer a very generous settlement and try to get the claims resolved. And so having the analysts coming in now and criticizing BP is not good for the company either. So stay tuned. It's going to be a very interesting case. And I think I have a few minutes to answer some questions. Thank you. Yes.